My name is Lee Katz. I serve as the Dean of Seaver College, and welcome to the W. David Baird Distinguished Lecture Series. Yes, David Baird was the Dean of Seaver College from 1998 to 2008. He was a historian. He was a mentor to many of us, for many of us, and he just passed away just last year. He founded this lecture series to welcome scholars, public figures, intellectuals to campus to foster important discussions within our community about topics and matters that we care about. What I love, and as I attended many of those lectures over the years, I would admire the speaker, the external speaker, and then I would often think and say to myself, we have experts that good or maybe even better on our own faculty here at Pepperdine. And so, as some of you may know, we are now hosting some of our own scholars, our own faculty members, as key speakers in this lecture series, and I'm delighted that we are doing that. Just a little bit about the format. The speaker will speak for 30 minutes, 35 minutes or so, and then we'll have time for questions and answers. At this point, I want to introduce Dr. Stella Erbs, the Divisional Dean of the Humanities and Teacher Education, to introduce our speaker. Dr. Erbs.
Whoops. Here we go. Well, hello, everyone. Thank you so much for being here. I am here to be Dr. Bonnici's hype girl. Not that she needs one, but I am happy to be one, okay? So after graduating from Harvard, a little school named Harvard, yes, Dr. Bonnici earned her JD at New York University. Most students out there, after you leave here, if you decide to go get a JD at New York University, you might say, okay, I'm done. I'm a JD, right? But not Dr. Bonnici. No. She went on to practice law in Alabama and in California, and then decided, I'll go earn an MFA in poetry from the University of California, Riverside. So now we have a BA, a JD, and an MFA in poetry. So you think, 3 degrees, let's be done. But no, not Dr. Bonnici. Dr. Bonnici decided after that she would also get a PhD in English from UCLA, okay? Dr. Bonnici is a unicorn, people. I have brought you a unicorn of academics, okay? Dr. Kate Bolton Bonnici is an assistant professor of English here at Seaver College, go Waves, at Pepperdine University in the Humanities and Teacher Education Division. You didn't write that down, but I had to give our division a shout out, okay? And she directs the SAGE program. Any SAGE people in the house today? Thank you very much. Okay, she's the director of that program. Dr. Bonnici is an interdisciplinary scholar who recently published A True and Just Record about the English witch trials. Her debut poetry collection, Night Burial, won the 2020 Colorado Prize for Poetry, and a new hybrid collection is forthcoming from Cornerstone Press, University of Wisconsin, Stevens Point. In today's talk, Minding Justice, Mental Health, and Criminal Law, Dr. Bonnici incorporates insights from her work in rhetoric, early modern studies, and criminal defense to introduce Mental Health in Criminal Justice, a practical guide for legal and clinical professionals, a book she is co-editing with Dr. Diomaris Safi from UCLA, and that will be published by the American Bar Association. Besides all of these credentials, everybody, and the fact that I went over the rainbow to get Dr. Bolton Bonnici for you, I just have to personally say that it is an honor to have someone with such a high standard of excellence teaching our students and directing the SAGE program at Seaver College. Dr. Bonnici makes all of us better here at Pepperdine, in our division, in the SAGE program, and those who have the good fortune to work with her. I have the good fortune to work with her and call her my friend. Ladies and gentlemen, Dr. Kate Bolton Bonnici.
All right. I'm somewhere in the middle. Okay. So good afternoon. Thank you all so much for being here today and for joining for this discussion of my collaborative book project, Mental Health in Criminal Justice, a practical guide for legal and clinical professionals. Thank you, Dean Erbs, for that very kind introduction. And thank you to Dean Dana Dudley and Dean Lee Katz for the the invitation to share this work with you today. I also want to thank Pepperdine Libraries and Jeffrey Bowen for hosting us in this really beautiful space. And before I start, I also want to acknowledge the passing of our colleague, Professor of Psychology, Dr. Stephen Rouse, whose work intersects with the subject of this talk and who tirelessly advocated for justice. And so I want to hold space here for the grief for that loss and our gratitude for his work. Today's talk centers not knowledge directly, but a lack of knowledge, a space of not knowing where knowing should be. But before I speak more about this book, or more accurately, as a way of entering the space of not knowing this book addresses, I want to take a detour in time and place and tell a story. Our setting is England, 1621. Residents of the village of Edmonton accuse a local woman named Elizabeth Sawyer of causing damage and death to their children, their livestock, and other members of the community through the practice of malevolent witchcraft. On April 14, Elizabeth Sawyer is indicted. There are fascinating aspects of her story, including, for example, the allegation that she had a diabolical dog familiar who drank blood from her body, and that after hearing testimonial evidence against her, the jury was not entirely convinced of her guilt. And so they convened what's known as a jury of matrons. In this case, women who were selected off the street because they happened to be walking in front of the courthouse. And they had this jury of matrons search the body of Elizabeth Sawyer against her will, looking for what's known as a witch's mark on her body. On April 19, 1621, Elizabeth Sawyer is executed by hanging. We know her story in part because it circulated in various forms. Soon after her execution, Henry Goodcole, a chaplain of the London prison where she was held, published a pamphlet. You can see the cover of the pamphlet here, and it was entitled, "The Wonderful Discovery of Elizabeth Sawyer, a Witch, late of Edmonton, Her Conviction and Condemnation and Death." And in the pamphlet, Goodcole claims to be an objective observer of the trial proceedings and a conveyor of authentic information. He says, meddling herewith nothing but matter of fact. That same year, a play called The Witch of Edmonton by William Rowley, Thomas Dekker, and John Ford was first performed, and a print copy of the play was published in 1658. Here's a depiction of the cover of the play that's held at the Huntington Library just down the road. Now, scholars of history, law, cultural studies, religion, and literature have generated copious materials on the early modern witch trials. They've sought to understand why particular beliefs come to the fore, why such beliefs persist, why periods of accusation and execution arise and decline, where and when which beliefs occurred or occur, who is targeted, who targets, and how this all plays out. Now, these are excellent questions, and I shall not venture to answer such questions today, but instead come at an issue more angled and quietly but persistently invidious. What I want to consider is a passage from Henry Goodcole's pamphlet, the one y'all saw the picture of 2 slides ago, in which he describes how he interprets Elizabeth Sawyer's bodily manifestations of guilt. Goodcole writes, and I quote here, "Her face was most pale and ghost-like without any blood at all, and her countenance was still dejected to the ground. Her body was crooked and deformed, even bending together, which so happened but a little before her apprehension. And she was not able to speak a sensible or ready word for her defense." These descriptions call to mind a contemporary handbook that barrister, justice of the peace, and legal writer Michael Dalton wrote and published in 1618 to help other justices of the peace perform their judicial and administrative duties when they had no or very little training in law. Dalton's handbook, and the cover's on the slide, is called The Country Justice, containing the practice of the justices of the peace out of their sessions, gathered for the better help of such justices of peace as have not been much conversant in the study of the laws of this realm. And it went through approximately 20 editions in England and in the American colonies. Country Justice has a section on examination that lists what circumstances should be considered when examining felons and other offenders. Specifically, this subsection I pictured here, marks or signs, includes as indicators of guilt the change of an examinee's countenance, his blushing, looking downwards, silence, trembling, and if being charged with a felony or called these, he saith nothing. Read through the lens of Dalton's judicial advice, Goodcole's observations on Sawyer's behavior appear to support a conclusion of guilt. Now, a lot has changed, certainly, from the early 1600s to 2026. For example, in Dalton's Country Justice, the line item just before he saith nothing, if you see just above here, that one, that line item instructs the justice of the peace to look for something known as cruentation. That is the bleeding of the dead body in his presence. Now, the belief that a murdered body will bleed from its wounds in the presence of its murderer no longer forms part of our cultural expectation or legal practice. And similarly, we do not overtly express a belief in physiognomy, that a person's inner condition manifests in their outer appearance, which would be an explanation in 1621 for why Sawyer's guilty body purportedly grew crooked and bent just prior to her arrest, and which is a subject area scholars in disability studies have explicitly addressed. Perhaps we scoff at these misguided attempts to read physical gestures as telling because of their proximity to conclusions we know now to be incorrect. We know Elizabeth Sawyer did not cause the death through malevolent witchcraft of neighbors or cattle or children in her village, just as we know that if you bring an accused up next to the body of the one whom they supposedly killed, the body of the deceased will not start spontaneously bleeding. We know physiognomy to be a mistaken and prejudicial practice. Knowing a conclusion's falsehood helps us discredit the erroneous steps in the chain of argumentation that get us there. And yet, pernicious similarities persist, specifically in how we continue to understand and misunderstand certain more subtle behaviors. Country Justice tells us that looking down, trembling, and silence are indicators of guilt. Goodcole records Elizabeth Sawyer's pale face and dejected countenance, how she could not speak a sensible or ready word for her defense. Might we not be tempted to read something of substance in these gestures, to read them, in fact, as telling marks or signs? Here's another story. I spoke with a lawyer recently about a case he had some years back. This lawyer represented a young man accused of committing a violent crime, but there was very little evidence actually connecting the young man accused to the event. So the prosecution's case was weak, and the prosecution has the burden of proving guilt. Case went to trial, the jury deliberated for about a half a day, and came back surprisingly with a guilty verdict. This young man went to prison for life. Now, in some jurisdictions, sometimes after trial, you're allowed to interview jurors, which is what the attorney here did. Turns out the jury agreed the evidence was weak. But one of the 12 jurors noticed that during some of the testimony, the young man sat in a particular way at counsel table. He sort of held his hands near his neck like this. And the juror thought it looked like this young man was making a gesture like he was choking himself, which the juror interpreted as the young man seeking to punish himself, which the juror then interpreted as evidence of his guilt, and convinced the other 11 folks on the jury that this was the right conclusion, hence guilty verdict, hence life in prison. So the lawyer who represented this young man now advises all his clients to sit with their hands in their laps, out of view of the jury, so there's no risk that any nervous gestures or hand-wringing will be interpreted as a mark or sign of guilt. So a lot has changed from 1618 to 2026. In fact, because so much has changed, it's easy to overlook what has not. So, moving us into the present, into the generatrix of today's lecture, this forthcoming book, Mental Health in Criminal Justice, a practical guide for legal and clinical professionals, my short title. And this is an edited volume I'm collaborating on with Dr. Diomaris Safi. Dr. Safi is a licensed psychologist who specializes in neuropsychological and forensic evaluations, and she founded and directs the Justice and Criminal Neuropsychology program at UCLA. And we started working together in summer 2023 to address the often devastating knowledge gap that exists in this overlap between mental health conditions and the criminal justice system. By mental health conditions, I mean broad categories, from minor to major, some of which rise to the level of disorder as defined by diagnostic criteria, and some of which do not. I also refer today to mental illness and to psychiatric, neurocognitive, or neurodevelopmental conditions or concerns. By criminal justice system, which is also referred to as the criminal legal system, I mean that system of prosecuting, defending, and sentencing those accused and potentially convicted of the commission of a crime. The problems, as Dr. Safi and I frame them, are these. Mental health conditions disproportionately affect those involved in the criminal justice system, and each justice-involved individual regularly interacts with attorneys, but yet those same attorneys rarely know how to identify, work with, or respond to mental health conditions in their clients or the accused in a criminal case. So to break this down a bit, I want to offer some specifics while keeping in mind that individuals with mental health conditions, especially severe mental illness, are far more likely to be victims of crime. So that's a very important caveat or thing to keep in mind in hearing this. So while approximately 1 to 2% of the general US population has an intellectual developmental disorder, up to 10% of the incarcerated population does. A recent survey by the Bureau of Justice Statistics, which is a part of the DOJ, indicates that almost a quarter of those incarcerated report having a cognitive disability. And according to the ABA criminal justice mental health standards, the literature indicates that 16 to 24% of people in jails and prisons have a serious mental illness, which is 3 to 12 times higher than community rates. And if you include personality disorders, these percentages shoot up to over 50%. Now, behind the percentages that I just quoted are individuals navigating a very complex system. And each justice-involved person interacts with attorneys, so they've got their lawyer, bless you, counsel for the defense. So unlike in Elizabeth Sawyer's time, the Fifth and Sixth Amendments to our Constitution guarantee representation for someone accused of a crime. And you have the prosecution, so lawyers who, on behalf of the state or federal government, seek indictments, negotiate plea bargains, try cases. And importantly, you also have the bench, the judiciary. They are also lawyers who, through election or appointment, preside as judges over criminal cases. And despite this overrepresentation of persons with mental health conditions in the criminal legal system, interacting with lawyers all the time in various capacities, the lawyers in the system, defense, prosecution, and judges, rarely know how to address it. Because most law schools offer limited training in representing a client with a psychiatric or neurocognitive disorder, attorneys enter legal practice with very little understanding of how mental illness could become a part of their work. Defense lawyers may not understand their client's conditions and may not know how to apply the law to the facts of the case, or how to seek mitigation, or how to persuasively articulate their client's story. Prosecutors may actively argue against restorative justice or treatment options or diversion for defendants without grasping the role that mental health conditions can play in a case. As the ABA recognizes in commentary to their criminal justice mental health standards, and I'm quoting here, judges may be impatient with defendants, particularly if they see them in their courtrooms repeatedly and are provided no explanation as to why. So this disconnect increases the chance that those accused of a crime who have a mental health condition will receive inadequate representation and adjudication, leading to a range of injustices. So just two examples, two hypotheticals. Consider on the one hand, a teenage client, an adolescent client with ADHD, who may be looking around the courtroom or shifting in his chair. And that could lead a judge to consider such behaviors not as consistent with ADHD, but as indicative of boredom or disrespect or even guilt. Or perhaps you represent an adult client accused of battery, and you, the attorney, do not understand her full history of trauma, say, or her neurocognitive disorder, because there's been no school documentation, or perhaps there's only a limited family history, or there's masking because of deeply rooted stigmas involved, or your client doesn't understand, perhaps, that they have a particular condition. There could be a language barrier. And the end result may be that you don't recognize the need for mental health expertise in case preparation and litigation. So what I'm describing is a knowledge gap that can have devastating consequences. So to address this gap, We've curated mental health and criminal justice with chapters written by experts in forensic psychology, neuropsychology, psychiatry, and law. And the book project recognizes a need for interdisciplinary collaboration, specifically between legal and mental health professionals, while also recognizing the challenges of such collaboration. The goal of the book is to provide accessible, necessary resources to enable robust representation of and engagement with individuals who are involved in the criminal legal system and who may have psychiatric illnesses and/or cognitive impairment. And the result will be more just outcomes. So mental health and criminal justice is organized in 3 parts. Part 1 is advice for mental health professionals that lawyers need to know. And the objective of this section is to offer clinical insights relevant to law, so mental health professionals working in forensic, that is legal settings, get a meaningful overview of key concerns. And lawyers can peer behind the curtain to better understand what objectives, tools, and parameters motivate and constrain mental health work. So here's an example. In 2002, in the case of Atkins v. Virginia, the Supreme Court of the United States established a constitutional prohibition on the execution of individuals with intellectual and developmental disabilities. And while IDD is defined in the Diagnostic and Statistical Manual of Mental Disorders, which is the handbook used by healthcare professionals in the United States as the authoritative guide to the diagnosis of mental disorders, DSM criteria work for and are designed to work for clinical diagnoses and treatment. They don't track perfectly onto forensic evaluations, which are the evaluations for legal purposes. And the DSM actually has a prefatory disclaimer titled Cautionary Statement for Forensic Use of DSM-5. So the Atkins Court left the definitions and implementation of its standards up to the states. And as you can imagine, the states have handled that very differently, coming up with really divergent strategies. In fact, there's a recent case out of my home state of Alabama, Ham v. Smith, that was argued before the Supreme Court in December. And that decision will have an impact on how attorneys and mental health professionals working on a legal team together argue IDD and sentencing. So as soon as that decision comes down from the Supreme Court, the book chapter addressing intellectual and developmental disabilities in capital defendants, so cases where the death penalty is at issue, that chapter will incorporate this new guidance for practitioners to create a comprehensive and current set of suggested practices. Other parts of this section include the role of trauma among criminal defendants and the importance of trauma-informed evaluations that lawyers need to know to ask for. Also, understanding the neurodevelopmental and psychiatric conditions that affect children and adolescents, especially where a child could either be charged with a crime or be diverted into treatment. So part 2 shifts gears into advice for lawyers that mental health professionals need to know. And this section emphasizes how lawyers can become better informed about mental health concerns while preparing a legal case. So how to litigate areas such as competence, intent, the admissibility of statements to law enforcement, how to advocate for mitigation, sentencing, and diversion strategies, including through collaborative court options such as mental health courts, and how to prepare a case for trial where mental health conditions form some part of the underlying story. That is how lawyers can familiarize themselves with general diagnostic criteria and practices and with their client's particular history in order to craft a persuasive narrative in court. We consider as well how to work in interdisciplinary teams when your cohort of attorneys and mental health professionals are governed by different training, different protocols, different ethical and professional expectations, and different goals. So, for example, defense attorneys are part of an adversarial system. Yes, you're an officer of the court, and you are also professionally obligated to be a zealous advocate of and counselor to your clients. So as an advocate, you've got to have a theory of the case that you articulate through story and through argument. Okay, a quick aside. Here at Pepperdine, I'm an English professor in rhetoric and writing, and there's a reason why this course of study serves as a strong preparation for law school, because students are trained to study languages, persuasive capacities, which is much of legal work. But then on the other hand, a mental health expert acts under a fundamentally different mandate. Especially in a forensic context, their professional obligations require focus on objectivity, not advocacy. So they're thinking data, methodology, impartiality, transparency. These are the objectives. So what I'm describing is interdisciplinary collaborations where the originating functions and operating rules of the two disciplines can seem almost antithetical. But where shared language and some cross-disciplinary education will lead to more just engagements. The last section of the book moves into systemic concerns and best practices to examine the intersection between mental health and criminal justice through the lenses of sociology, psychology, and law. So we consider broader concerns, for example, how to apply a socially responsible education model to legal processes, along with some very specific developments. So for example, the neurocognitive unit model that has been developed by the Los Angeles County Public Defender's Office and is a cutting-edge approach to taking a holistic approach to advocacy by working with mental health professionals to provide necessary wraparound services to clients and avert cycles of recidivism. Now, because we're at Pepperdine, where teaching is paramount, I'll conclude this overview of the book by mentioning the concern of the book's last chapter, pedagogy. And here, Dr. Safi and I focus on the educational preparation of lawyers and the importance of addressing in law school the relationships between mental health conditions and criminal justice. So we reached out to, with the help of a student here at Pepperdine, obtained substantive curricular information from most of the 198 ABA accredited law schools in the country, and we analyzed these materials to tell us to identify and quantify current course offerings related to mental health and law, answer very few, to determine what courses might prepare attorneys for better legal advocacy, and to suggest curricular enrichments to and challenges for the goal of establishing a replicable framework by which lawyers can begin to acquire the tools they need to practice at a more just intersection of mental health and criminal law. I began this talk in the early 17th century, and I want to return there. In Henry Goodcole's pamphlet, when the villagers begin to grumble about Elizabeth Sawyer and think her responsible for their troubles, they try a particular method for calling out a witch. They burn a piece of thatch from her house to see if she comes running. And she does. Goodcole dismisses this in his pamphlet as an old, ridiculous custom for determining guilt. And we can agree with him. Burning a piece of straw to summon someone is a ridiculous technique. Or we can at least look upon such practices with distant, estranged fascination. Now, I've offered the story of Elizabeth Sawyer today because it provides us with examples of flagrant extremes. Here's a woman convicted of and executed for the commission of a crime we know cannot be a crime, and who's found guilty in part through physical indicators of wrongdoing we know are not true indicators. That is, her body did not bend together as an external reflection of an inner sinful state. She bore no real marks caused by a diabolical nursling. Her body instead bore the marks of other inequities, wrought by gender, poverty, disability, illness, age. I also do not mention this story in order to anachronistically make a claim about connections between present-day mental health conditions and 17th century beliefs. I am not seeking to braid current diagnoses into a specific historical scenario in a way that would ignore geographic, temporal, and cultural specificity. In fact, the witch trial aspect of her case is itself a bit of a red herring. Elizabeth Sawyer's story matters to us right now for its more subtle moments of judgment. Reading a pale countenance, the appearance of dejection and silence as indicators of guilt that echo the guidance from Dalton's Country Justice, where he writes, "Now upon the examination of felons and other like offenders, these circumstances following are to be considered: the change of countenance, his blushing, looking downwards, silence, trembling." In the 21st century, while we have moved beyond the search for a witch's mark, we still rely on signs such as these as we seek to read in each other behavioral cues for how to interpret a situation. Now, psychologists may have the clinical expert experience and know how to engage in such interpretive readings. The rest of us lay persons fumble along, trying to understand each other, trying to communicate. Yet if you are a participant in the criminal legal system, your lay interpretations can have consequences. And if you are an attorney, you are often working from a position of presumed but limited expertise. Most of your legal training likely involved memorizing rules and doctrines and applying them to varied hypothetical fact patterns. But your actual practice can look far different. Attorneys are educated and licensed as generalists, even if we go into more specialized subject areas. So, for example, the California bar exam is coming up in a couple of weeks. And attorneys would-be licensed attorneys sitting for that exam have to be prepared to answer questions on business association, civil procedure, community property, real property, contracts, constitutional law, criminal procedure, remedies, torts, trust, wills and succession, evidence, and professional responsibility. So my question is, where in this list do we learn how to prepare a client to sit beside us in a courtroom where he will be evaluated, at least implicitly, based on his appearance, his mannerisms, his gestures, his expressions, and what he does with his hands? How about learning to manage a social history investigation? Where do we learn how to conduct an intake with a client who may have a mild intellectual and developmental disability that, given the stigma attached to many diagnoses, they have worked for years to mask? Or say your client's incarcerated and you're in a jurisdiction that does not allow in-person meetings with counsel, and you're trying to evaluate this person's case while speaking via screens. What if your client struggles to answer questions or to make eye contact? How do we know when a client should be evaluated by a professional in mental health? What type of expert should do that evaluation? what type of evaluation should be conducted, and what to do with the information we obtain. The goal of our book is to facilitate more just outcomes by providing some direction when these questions arise. Because the practice of law requires more than memorizing doctrinal rules. As Anthony Amsterdam and the late Jerome Bruner explain in their influential book, Minding the Law, becoming a lawyer is learning what is involved in lawyering. In 1618, Michael Dalton wrote in the dedicatory materials to country justice that because a want of knowledge, he called it, impeded the discharge of duty, he, quote, endeavored to set down things plainly and briefly, whereby the reader may better resolve and satisfy himself what he ought to do. We seek to do the same. So thank you.
Thank you so much. Maybe on. Thank you so much. That was really wonderful, and I really appreciate you being here, and I appreciate all of you. And we're going to open it up for Q&A. If you have a question, please raise your hand, and then introduce yourself and what division you're from if you're a student. Oh, here.
I'll give you all students some time to think. How about that? So thank you so much, Dr. Bonnici, for that amazing presentation. So you, obviously as a scholar, you're posing so many questions, and so I want to kind of throw one back at you. I wrote it down as a question, and I heard you kind of say it. That okay. I'm hoping maybe you will have a thought about this. So you talked about the need to train lawyers in law school. So what does that training with actual people look like currently in law school? And then how do you imagine it evolving so that they are better prepared to navigate some of the topics and issues that you described?
Thank you for that great question. So currently, all law students have a set of required classes. The class that we are focusing on would be a criminal law class that all law students take. So there'd be your 1L crim law class. Currently, most crim law classes will touch on potentially on competence and potentially on not guilty by reason of insanity defenses, but maybe nothing else. So one of the things we've been looking at, and we've been sort of collating and deciphering syllabi from around the country to figure out what's being offered in these 1L crim law classes and how we could make it slightly more robust, because any attorneys going into criminal practice are going to run into these issues. So that's one option. The second option is looking at what kind of electives are being offered at the intersection of mental health and law more broadly, and sometimes specifically at the intersection of mental health and criminal law. And the good news is there are an increasing number of electives available in law school at this intersection. Option 3 then is in clinical programs. So clinical programs are where you, as a law student, work often on real cases with alongside real licensed attorneys. And so it's a kind of like an internship. It's like practical, hands-on experience. And there are now more clinical opportunities that are thinking about this mental health, criminal law intersection. Or as you can imagine, mental health intersects with a range of areas of legal subject areas. The thing that Dr. Safi and I have been concerned about, though, is trying to make sure that there's a little more information in the required 1L crim law class to make sure that you get the information to as many would-be lawyers as possible. I think they're
Here. Hi, I'm Adelaide Lowry. I'm a creative writing major. I had a question. It's kind of a two-part question, but I believe I've heard that underprivileged and impoverished communities in particular end up with higher crime rates. Do you believe that mental health impacts this? Is there a lack of mental health support for these communities, or is there another issue? Or maybe what would you suggest in terms of community rehabilitation?
Really, yes to all of that, Addie. There's so many complex layers of things happening in terms of access, over-policing, or lack of institutional supports, intergenerational impacts and traumas, right? And so you have a collision of many systemic and individual forces happening, such that you can have, so some of the numbers I showed that indicate high rates of individuals with mental health concerns in the criminal justice system. There are also extremely high percentages and rates looking at the vulnerabilities of individuals with mental health conditions to anywhere from more subtle to more violent crimes. And then those factors have a relationship. So we have two sociologists who are working on a chapter that are really looking at some of these systemic concerns and thinking about how, especially as practicing lawyers, if you're in the trenches on thinking about case-by-case basis, right? You may not be thinking as much about systems as you are thinking about just the individual in front of you, what's their school history, what's their family history, what's the police report for them. And so a reminder, this chapter is kind of serving as a reminder to also step back and think about systems and how the systems or systemic concerns are helping lead that person to your door. So there's a chapter that some attorneys from the LA County Public Defender's Office are writing, where they're talking about just asking the question, why is this person here today in court or in my office? And the answer to that question is always a long, complicated one that requires us to ask questions that go beyond, checking boxes on, like, did you commit this legal offense, right? So my answer to your question is really just a yes. You're raising crucial issues that are a really important part of the conversation.
There in the back.
Hi, my name is Marin. I'm studying in political science. Thank you for coming. This was phenomenal and it's such an important topic. My question is maybe a little bit more procedural. You raised the story of the jurors and very, very jarring. What are jurors told, if anything, regarding this topic of body language of the accused? And yeah, just maybe speak a little bit more on the logistics.
Well, so what the juries get are jury instructions that would tell them what ultimate question of fact they're meant to be answering. And that would be the elements that form the crime itself or whatever it is, sort of legal question they're charged with answering. So in terms of their kind of human decision-making processes, sort of how we all engage in these ways of reading each other and what they bring in, they're not told not to do that. Right? So often it's up to the lawyer to think about, how's my client presenting in court? How am I presenting in court? How are we going to be visibly read and deciphered? And so is the story I'm articulating, if I'm trying to explain sort of what's happening, why my client's here today, the story I tell, through the questions I ask witnesses, through opening and closing, that story has to comport with the visuals. And so you're having to think about a sort of performative aspect too, because you don't know what's going to happen in that room when those jurors are deliberating and what they are going to bring in to the decision-making process.
We have one more question over here, and then we are going to release you so that you have time to get to your next class.
Oh. Hi, Dr. Bonnici. We just read in class about a poem about homelessness, and that got me thinking about this. How do you think the legal system should respond differently to people experiencing homelessness, especially because untreated mental illnesses is part of the reason they're being criminalized in the first place with loitering and just like public living?
Yeah, so that's another great question. Thank you. So there's a chapter in the book written by Judge Carlin, who's a judge here in Los Angeles County, and then a public defender in Riverside County. And one of the things that they're addressing is some of the steps that Los Angeles County has specifically taken, but other jurisdictions have as well, to create what's known as collaborative courts. And this is only one answer to your question, which is, again, Iris, like getting at a major underlying issue. And so the collaborative courts are looking at ways to address needs beyond just, a guilty verdict or not, sentencing or not, but think about housing, substance use, other co-occurring medical conditions, purpose in life, employment, educational supports, neuropsych testing, if that's available. So to think about these more complex pictures, which we are all complex pictures, right? And so often, especially in a straight adversarial system where you're just thinking guilt or innocence, it doesn't reflect the complexity of that picture. So the mental health courts, or veteran courts, drug courts, homelessness courts, are trying to take a deeper, more comprehensive look at the community members, all of the community members who are there in order to have a system that is concerned with restorative justice. Yeah.
Thank you. Thank you all
Thanks,
for
y'all.
coming, and thank you, Dr. Bonnici. So as you know, this book, Finding Justice, is forthcoming, but her previously published book is being fashionably late and will arrive in the bookstore tomorrow. And so if you are interested in that book, drop by the bookstore. We'll have some posters of this so you'll recognize it right away. But we want to thank you all for coming. I also want to thank the whole team of people who make this possible. Leslie Sia, who does all of the logistics, and then also everyone in the Seaver Dean's office who makes this day happen. So thank you and have a good rest of your day.